Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about telewarrants. Cases that should have gone to the Supreme Court of Canada, but didn't. Kevin Janvier was a person who was convicted of a number of offenses as a result of a search that was done on his home. The search revealed evidence that related to the offenses, and Mr. Janvier argued that the search violated his rights because it was authorized by a warrant obtained by telecommunication rather than an in-person warrant. This is known as a telewarrant. In order to obtain a telewarrant, the Criminal Code says that the application should specify why it's impracticable for the affiant to appear personally before a justice to seek the warrant. In this case, the incident took place somewhere that was several hours away at the time from where the nearest justice was located, and the question was this sufficient for a telewarrant to be granted? Obviously, this case raises very important concerns because a search of somebody's home is the most significant intrusion into personal privacy that you can have. In Mr. Janvier's case, items were removed from his bedroom, the most private part of your home. And so a telewarrant that authorizes somebody to go into that place where a police officer doesn't have to personally appear in front of a judge or answer any questions or explain the basis for the warrant, where a justice can't assess their credibility through the way that they're communicating to see whether or not it feels like they're trying to hide something. These things need to be taken seriously. And there's a long line of case authority that has suggested that impracticable can be just inconvenient to police, which seems like a really low standard to impose in circumstances where somebody's privacy in the most significant way is going to be breached. This deserves treatment from the Supreme Court of Canada. We've had very little consideration at the Supreme Court of Canada level in this country of when telewarrants should be authorized, and certainly none extremely recently. And as our privacy interests increase in our society because of the ways that we have more methods of having our privacy interfered with, so too should the Supreme Court of Canada's consideration of issues that allow police to invade that privacy, and sheer inconvenience of driving a couple hours for one police officer shouldn't be enough to authorize an intrusion into somebody's home. Unfortunately, the Supreme Court of Canada didn't hear this case, which means that hundreds, maybe thousands of other individuals will have their homes and their bedrooms searched on the basis of informations to obtain search warrants that are just faxed. That's a frightening thing. And the Supreme Court of Canada should take the next opportunity it gets to reconsider the telewarrant provisions of the Criminal Code and what the impracticable standard actually means. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.